Hi, this is Chris McKaylee, and today we're going to cover the 6 standards of review that the Office of Administrative Law utilizes in reviewing proposed regulations. So OAL, again, the Office of Administrative Law in California, plays several key roles concerning the rulemaking activities of our state's 200 plus agencies, departments, boards, and commissions. There's not just regular rulemaking, there's also emergency rulemaking and even petitions for review of alleged underground regulations that have to be undertaken by OAL. Most agencies in the state enjoy broad statutory grants of rulemaking authority. In some instances, the legislature has provided a limited grant of authority, and many, if not most, of those 200 plus regulatory entities have adopted regulations. OAL indicates that between 700 and 800 regulations are adopted each year by those state entities in the executive branch of government. Now, when OAL reviews regulations, its review is dictated by the California Administrative Procedure Act, APA. The APA is found in the California Government Code, and these 6 standards are set forth there as well as being defined for OAL to utilize to determine whether a regulation, again, emergency or regular rulemaking, was properly adopted. OAL reviews whether the process was complied with. It does not consider the substance of a proposed regulation. There are also quite a number of appellate court decisions interpreting these 6 standards that also provide additional guidance. So let's get into the 6 standards. Authority and reference are 2 standards. The authority standard is basically reviewing whether the proposed regulation states the provision of law which authorizes or requires the proposed regulation. The reference standard is basically reviewing whether the proposed regulation cites the law which is being implemented or interpreted. According to OAL, complying with the authority and reference standards involves a rulemaking agency doing 2 things: picking the appropriate authority and reference citations for the note that follows each regulation section that's printed in the California Code of Regulations, as well as adopting a regulation that is, in fact, within the scope of the rulemaking power that's been conferred upon that executive branch entity by state statute. By law, each regulation section printed in the CCR, again, the California Code of Regulations, must have a citation to the specific statutory authority under which it was enacted, or in this case, adopted, the CCR, and a citation to the specific statute or other provision of law that the regulation is implementing, interpreting, or making specific, which by statutory definition is what a regulation's purpose is. If the underlying statute does not expressly or impliedly provide authority, then it's void. The next standard is the consistency standard, and this standard is basically reviewing whether the proposed regulation is in harmony with and not in conflict with other laws. In this regard, the review focuses on whether the proposed regulation is consistent with the underlying statute. And according to OAL, consistency is viewed as whether the regulation is reasonably designed to aid a statutory objective, that it doesn't conflict with or is contradictory to any statutory provision. The next standard is the clarity standard, and this standard is basically reviewing whether the proposed regulation is easily understood by those who are affected by it. According to OAL, regulations are frequently unclear and unnecessarily complex, even when the technical nature of the subject matter is taken into account. And so that creates confusion among the persons who have to comply with the proposed regulation. The intent of this standard is to ensure that the rulemaking agency has drafted a regulation whose text is plain, straightforward, generally avoids technical terms as much as possible, using coherent and easily readable language. As such, OAL attempts to ensure that each regulation can be easily understood by those who are regulated by it and avoid instances where a regulation is unclear to the regulated community. The next standard that OAL uses is the non-duplication standard. And this standard is basically reviewing whether the proposed regulation does not serve the same purpose as any other state law or regulation. OAL explains that a regulation cannot simply repeat or rephrase a statute. In other words, a regulation should not serve the same purpose of an existing statute or regulation. If it does, there's no real justification in doing so. The final standard is the necessity standard. And this standard is basically reviewing whether the need for the proposed regulation has been demonstrated by substantial evidence. Here, the rulemaking entity must have a complete rulemaking file when it submits the final product to OAL, and that rulemaking file has to include all the materials and background information upon which the proposed regulation is based. And both the initial and final statements of reasons that are produced by the rulemaking entity must be thorough enough to explain why the provisions of the regulation are reasonably necessary to accomplish their stated purpose. The rulemaking file developed by the executive branch agency or department also has to identify and include in the formal rulemaking record any materials relied upon in proposing the provision and any other information, statements, reports, any data that the agency was considering or used in connection with the rulemaking action. Keep in mind that OAL is limited in its review of the record of the rulemaking proceedings, as well as the rulemaking file itself, which could be a 3-wing binder worth of material, and it could be multiple banker's boxes worth of materials. A court reviewing a proposed regulation is also limited to the documents contained in that rulemaking record. So it's important for the rulemaking agency to comply with all the requirements of the APA and that they have a complete rulemaking file to be reviewed by the OAL.